and forth open in this case.
Okay, what, before you move from one to the other, if you could let us know, that would help us follow you quicker.
Absolutely, Your Honor. That concludes our non-substantive matters, Your Honor, as well as some substantive. Oh, additionally, Your Honor, we do just want to kind of check. Are you okay with? We've talked to both the councils. They are fine with not having masks. We wanted to see if you were okay and the jury's okay.
I am okay. Is my jury okay? Yes, okay. Thank you for asking. I appreciate that.
And that concludes our non-substantive matters. Again, we do have one substantive motion.
Okay, we will return to you in just a second. Let's go with the motion to eliminate.
Yes, Your Honor, just for some brief context, we are here today because Mr. Williams was arrested and charged with possession with the intent to deliver a controlled substance, namely cocaine. Now, we anticipate that the state will attempt to elicit an alleged confession that occurred in the backseat of the detective's car after Mr. Williams was already arrested. For the benefit of court and counsel, it's located on pages 17, lines 7 through 17. In that conversation, Mr. Williams is in the backseat of the car. He then asked the officer if there's any way he can get out of what the charges he had just arrested for. At this point, the detective then responds and says, if you can complete your controlled buys, then I will ignore these charges. Mr. Williams then responds and says, he can't do that. He's not a dealer. He only had it for personal use. And we seek to exclude this as Mr. Williams was not Mirandized as he was under custodial interrogation at that time.
Well, yes, before we approach that subject, let's see what the context is at that time. So don't just go into it.
Your Honor, if you reserve your ruling on
I'm reserving my ruling.
And our second ground for our motion to eliminate, Your Honor, there was a gun, a firearm that was found upstairs in apartment number 103. We seek to exclude any mention of this gun. Additionally, Exhibit 6 has the gun picture in it. We move to exclude it as it's not relevant in today's case, and it's substantially more prejudicial. It will confuse the issues and mislead the jury.
What, if any, is the relevance of the gun in the case?
Yes, Your Honor. First of all, would you like us to show you Exhibit 6?
No.
Okay. Yes, Your Honor. The gun is relevant in today's case because it goes to show that there is more than mere possession in this. Several circuits have held that a gun in a narcotics investigation goes specifically to the intent to distribute element. These circuits are the 2nd, 3rd, 4th, 5th, 6th, 9th, 10th, and 11th circuits. Additionally, Your Honor, these circuits have all held that this was a tool of the trade in narcotics dealing. Additionally, Your Honor, in United States versus Cannon, which is a case out of the 9th Circuit, that court has held that a firearm, a discussion of a firearm in a case involving narcotics distribution was admissible.
How close was the gun to the drugs at issue?
Several feet away, Your Honor.
Okay. I'm going to reserve my ruling on that too. I'm going to look at the context a little closer as we get there. So I'm not going to exclude it at this time.
Mr. Honor, that concludes defense's motion.
For clarification, should the gun be mentioned in the opening statement?
No.
And one other additional thing, we would like to invoke the rule on Detective Ash Giddings and exclude Mr. Williams from the rule.
Actually, let's do that.
Thank you, Your Honor.
Mr. Giddings is not testifying as an expert, correct?
No, Your Honor, he's simply the leading narcotics detective.
He's a fact witness.
Yes, Your Honor.
Okay, then that's what we'll do.
Just to be clear, Your Honor, so he's not, he is.
He is excluded. He's subject to the rule.
Yes, Your Honor.
Okay. So did you have any further motions?
No, Your Honor.
Defense stands ready for trial.
Okay. And so what were your substantive motions?
Yes, Your Honor, we have one motion specifically regarding the defendant's silence at a specific moment in time. The reason that we're raising this pre-trial is so we know whether or not we can discuss this in opening statement because we anticipate defense may have an issue with it. The specific moment in time that we're talking about is when Officer Perez, the patrol officer who finds the cocaine, is carrying that cocaine down the stairs. The defendant never says, "This isn't my apartment." The defendant never says, "These are not my drugs." Your Honor, we intend to go into this in opening statement, and the Supreme Court has ruled in Jenkins v. Anderson that pre-arrest silence, the defendant was not under arrest at this point, is admissible to show, is admissible to impeach the defendant's credibility, which is what we're trying to do here. Additionally, Your Honor, the 11th, 5th, and 9th circuits have held that pre-arrest silence may be used in the state's case in chief.
May I briefly respond?
Yes, why don't we hear from you?
Your Honor, the state is attempting to use pre-arrest silence as his right against self-incrimination. It's his Fifth Amendment right not to say anything. It's improper for the state to proffer that to impeach him. When Mr. Williams didn't say anything in the first place, or when they tried to impeach him as to his knowledge of the gun and drugs that were found upstairs in the apartment, it's improper to use his Fifth Amendment right against him. It's his right for a reason.
We're gonna exclude that.
Yes, Your Honor.
And if there's anything down the road that would change your argument about that, we can discuss it before you get into that.
Yes, Your Honor. With that, one brief housekeeping matter that's personal to me. I am recovering from a bit of a brief cough. It is not COVID related. I just wanted to ask the court's permission to leave the courtroom if it acts up so I don't interrupt anyone's examination.
Of course. Do you have some water?
Yes, I have water and
Okay.
cough drops. It's not candy, just wanted to make the court prepare.
That's fine.
Yes, thank you, Your Honor. With that, the state is ready to proceed.
All right, let us begin.
Your Honor, may I set up before we begin?
Yes, of course.
May please report.
May continue.
Once you catch somebody in a lie, you should question everything they say. That's because you can't trust somebody who doesn't tell the truth. The defendant in this case is a drug dealer. The drug dealer tells stories to hide his dealing. He tells stories to stay out of trouble. You'll see that that's exactly what the defense will do. July 30th, 2020. The defendant's relaxing alone in his small apartment in the Red Bud apartment complex. Relaxing, enjoying his day, but there are a couple of important things in the apartment. Upstairs in the defendant's bedroom, on his nightstand, there's a clear sandwich bag that has a little bit of cocaine. Next to it, there's a small turquoise bag that's full of cocaine. Downstairs on the defendant's kitchen table, there's a small electric scale that he uses to weigh that cocaine. A dozen or so small empty turquoise plastic bags and some cut-up straws. See, in the apartment of the defendant are the tools of his trade. What he would do is he would take the cocaine out of the larger sandwich size bag, scoop it into those smaller turquoise bags, place it on the scale to make sure that he's got the precise amount, and then he would sell it to other people. So July 30th, 2020, the defendant's relaxing when suddenly he hears a knock at the door. He gets up, walks to the door, turns the lock, and opens the door to find several uniformed police department officers. Immediately, the defendant blurts out, "My name is Tommy Williams." Police officers ask to see some ID. And it says, "I don't have that on me. That's out in my car in the parking lot." So Officer Courtney Perez, the first to arrive on scene, walks out to the parking lot with the defendant. He rummages around in his car for a while until he finds what he's looking for. He hands Officer Perez an ID with the name Tommy. At this point, Officer Perez tells the defendant that they're there to check up on a child endangerment call, make sure that there aren't any kids being held against their will in the apartment. And she asks for his permission to search the apartment. The defendant, knowing that he was alone in that apartment, agrees, and he signs the consent form for the police to search as Tommy. For the third time that day, representing to law enforcement that is who he is. So Officer Perez goes in, she conducts the search, and she doesn't find any kids in danger, but he does find those two bags of cocaine upstairs on the nightstand. So Officer Perez calls the narcotics detective Ash Giddings to the scene, investigates and ultimately arrests the defendant. Now, when Detective Giddings arrests the defendant, they drive to the jail. When they get to the jail, Detective Giddings goes to do some paperwork, and the defendant goes to get booked in. While he's getting booked in, one of the intake officers approaches Detective Giddings and says that there's been a problem with the defendant's fingerprint. You see, all day he's been telling law enforcement that his name is Tommy Williams, but his fingerprints match someone by the name of Timmy. Frustrated, Detective Giddings approaches the defendant and says, "We have your prints in the system. We know that your name is Timmy, not Tommy, so just tell me, is your name Timmy Williams?" And it's at this point where the defendant drops the act. He nods his head. See, the defendant's name is not Tommy Williams, despite what he repeatedly told law enforcement on July 30th. Tommy Williams is the defendant's twin brother. On July 30th, 2020, the defendant told law enforcement that his name was Tommy Williams to try and stay out of trouble, try and stay out of jail. But that disguise, it didn't work. As the state, we charged the defendant with possession with intent to deliver a controlled substance. In this case, that controlled substance is cocaine. As the state, we bear the burden of proof. We must prove to you that the defendant knowingly possessed that cocaine and intended to transfer it to another person. Now, beyond a reasonable doubt, that doesn't mean beyond any and all doubt. Doesn't mean beyond any and all question, but beyond a reasonable doubt. We'll meet that burden today by calling a few witnesses. But first, you'll hear from Officer Courtney Perez. When Officer Perez takes that stand, I want you to listen for how many times throughout the course of his investigation the defendant lied. Officer Perez. You'll also hear from Detective Ash Giddings, who will tell you about the fingerprints in jail. Now, this investigation by the police, it wasn't perfect. There were some mistakes that were made, but these mistakes don't take away from a few fundamental facts. The fact that the substance in these bags, the white powdery substance, is cocaine. That these bags were found in the same compartment as a small digital scale, a dozen or so empty turquoise bags, just like the one that the cocaine was found in. The cutoff was. And the fact that all of this was found in the same apartment as the defendant. We anticipate in a moment that the defense will get up here and try and tell you a new story. A story that this wasn't the defendant's apartment, that these weren't the defendant's drugs. The defendant can no longer hide behind his brother's identity. The defense will be forced to tell you this new story. Hear this new story, I want you to remember that you can't trust somebody who doesn't tell the truth. Once you catch someone in a lie, you should question everything they say, especially when they lie about something so simple, so basic. The answer to the question, what is your name? The statement? Yes. May it please the court. An inadequate investigation leads to unanswered questions. The evidence will show that on July 30th, 2020, the Canadian police officers contaminated evidence. We learned that it's that same evidence that was taken to the lab and tested. And it's that same evidence the state is using today to attempt to convict
Mr. Williams of a crime he did not commit. But before we get into what occurred on July 30th, 2020, I want to take a moment and introduce Mr. Williams. This is Timmy. He's a hardworking father of 5. You've probably seen him around town. He's a cook at your local KFC. He helps an elderly man out on the ranch as a ranch hand, helping him in the day-to-day. Learn that Mr. Williams is not a perfect guy. He's made a lot of mistakes in life, serious mistakes. Mistakes that have affected his way of going about life. Mistakes in the way he conducts himself. But in order to understand Mr. Williams and understand how we are here today, we have to go back to July 30th, 2020. That day, Mr. Williams got up. It was a hot day, it's July. He decides, hey, this is a perfect day to go to the lake with my brother and my sister-in-law, Tommy and Beth. So Mr. Williams, he gets up, he gets dressed, he drives the 30 miles into town. But when he gets to his brother's apartment, his brother's back to him. And then his wife can go visit him. So Mr. Williams, instead of driving 30 miles back to yes, okay, is it okay if I just hang out until you guys get back? That's fine. We'll only run a couple hours. You'll learn that Mr. Williams' brother is very particular about particulars kind of a stretch. He has one thing rule. Don't sleep on the couch. So Mr. Williams, honoring his brother, he makes a bed on the floor. There's no AC in the apartment, so he takes off his shirt, turns on the TV, and goes to bed. And all of a sudden, gentle knock. Light enough to make Mr. Williams up. He goes, he doesn't even put on a shirt. He just goes to the door and he opens it. And when he opens it, the penny police officers are at the door. You learn that, yes, Mr. Williams was nervous. Yes, he was scared. He was nervous and scared because he had sworn about the news. Because he had violated his probation. He couldn't afford to pay for it anymore with his 2 jobs. He was trying to catch up. Just need to know pay. Mr. Williams, nervous, afraid to go back to jail. He makes a decision. A bad decision, but a decision nonetheless, and he lies. Tells police that his name is Tommy Williams. He goes down to the car, he grabs an ID again for Tommy Williams. He even allows police to sign some consent form. Allow him to go into that car. And as he's walking with police officers to show them where he's sleeping on the floor, he's right there staying with them. Officer Courtney Perez comes down the stairs holding 2 bags of white substance that were found upstairs. However, you'll learn that soon after those bags were found, the investigation is pretty much over. Mr. Williams was arrested, charged, put in the back seat of a detective's car, and taken to jail. I want to take a moment to talk about the burden of proof. They touched on it some, but I really want to report you how important is Mr. Williams' freedom today. The burden is beyond reason. And that burden lies at this table and stays at this table throughout trial the entirety of the time. Beyond a reasonable doubt doesn't mean that Mr. Williams might be guilty, doesn't mean that he's probably guilty. It means that no one other than Mr. Williams could have committed the crime that's alleged today. And the state will not meet that burden. Now, the state just got up and told you their version of events. Here for 2 witnesses today on the state's side, Officer Courtney Perez and Detective Gibbons. Let's talk about what you're going to hear from those witnesses. Officer Courtney Perez is going to get up on the stand and tell you all about the search. learn all about how Officer Perez was called out for child endangerment. We'll also learn that Officer Perez searched apartment number 123, even though there were no signs of children. Searched the downstairs and didn't find any signs of children. We continued upstairs and still didn't find any signs of children. Members of the jury will be left to wonder, well, where are the children that brought them there in the first place? State will never answer that question. And as Officer Perez is conducting this search, there's 2 bags of white substance found on the nightstand. We learned that instead of following police procedure, putting on gloves, leaving the evidence where it was found, Officer Perez faced the decision. He decided that it's better to grab that evidence with the bare hands. Contaminated. We learned that no fingerprints were ever going to be able to be recovered from those facts because of that. You'll be left with the question, well, who other than Officer Perez touched the bags? And again, the state will never answer that question. Finally, after violating procedure upstairs, Officer Perez continues, violating procedure again, moves it, places it just so on the kitchen table. Just right. And then decides, oh, this is a good time to take a picture. Members of the jury will be left to wonder, what was the reason for moving it downstairs? Why was it important to violate procedure? Never. Then you'll hear from Detective Ash Giddings. Ash Giddings, an officer with 20 years of experience, 5 years in narcotics. You'll learn how Detective Ash Giddings was called out to that apartment to help those officers because of the mistakes that they had already made. Detective Giddings on that stand will have to admit to every single mistake that was made that day. Then Detective Giddings will talk about everything he did to help those officers. Members of the jury, you'll learn that it won't take long to talk about what Detective Giddings did, because Detective Giddings did 3 things. Collected the bags, collected Mr. Williams, and did some paperwork. Then went home and called it a day. I collected 2 hours and 15 minutes spent on this case. State is not enough to accept. One's a liar and you can't trust anything that they say. Members of the jury, keep in mind, there's not just going to be 1 violation of procedure, or 2, 2, 3. You'll learn that that's just what this officer does. Violate procedure without regard for the consequences. So as you listen to the state's case, and you have to decide the credibility of the witnesses that are on the stand, and the credibility of the evidence that is put in front of you, I want you to keep some questions in mind. Who other than Officer Perez touched those bags? Who else was a part in apartment number 123? Where is Tommy Williams? Where is Jennifer? Why was it important to violate procedure? Where are the kids that brought them to go to their apartments in the first place? Members of the jury, an adequate investigation will be leaving you with so many unanswered questions. Questions that will leave you with reasonable doubt. And the judge is going to instruct you on reasonable doubt. And instruct you that where reasonable doubt exists, you must agree. Find that Mr. Williams is not guilty.
We ready to proceed?
Yes, Your Honor, we call Officer Courtney Perez. The court, may I set up the courtroom?
Yes, of course.
Good afternoon, Officer Perez. Please introduce yourself to the members of the jury.
Hello, my name is Officer Courtney Perez.
What do you do for a living?
I am a police officer here in McKinney County, the city of McKinney, excuse me, and I serve the community as a police officer.
How long have you been with the King Police Department?
I believe 3 years.
What are your duties as a patrol officer?
As you mentioned, I patrol the city. I help address crimes and keep our community safe.
Okay, Officer Perez, I want to talk to you about one call in particular that you responded to, the Red Bud apartment complex, July 30th, 2020. Do you remember responding to that call?
I do, yes.
Okay, why were you called to the Red Bud apartment complex?
I had received a call while on patrol that there was a child endangerment issue at that apartment complex.
Okay, before we get any further, I want to make something clear. What county and state is the Red Bud apartment complex located in?
Yes, Collin County here in Lone Star.
Officer Perez, when you arrived on scene for this child endangerment call, were you alone or were there other officers?
I was alone, but once I arrived, I called for backup.
Did backup ever arrive?
It did, yes.
What was the first thing you did in your investigation once that backup arrived?
I knocked on the door.
Did somebody answer that door?
Yes,
Officer Perez, do you see the person who answered that door in the courtroom here today?
I do.
Would you point him out and identify him with an article of clothing?
Yes, he's wearing glasses and a blue suit with brown shoes.
Your Honor, may the record reflect that Officer Perez has identified the defendant as the person who answered the door.
The record will so reflect.
So, Officer Perez, what was the first thing that the defendant said to you when you knocked on that door?
Before I had the chance to say anything, he said, "My name is Tommy Williams."
Okay, I want to keep track of a few key things that the defendant said to you throughout the course of your investigation. Your Honor, may I approach the easel to create a chart?
Yes,
All right, Officer Perez, you just told the members of the jury that the defendant initially said, "My name is Tommy Williams." Had you asked him for his name at this point?
No, it's the first thing that was said when the door was open.
All right, so I'm gonna write one name, Tommy Williams. So after he told you his name was Tommy Williams, what did you ask the defendant next?
I asked the defendant to see some sort of identification.
Did you have that on him? Was he able to provide it right away?
No, he seemed nervous and he told me that the ID was in his car in the parking lot.
What did you and the defendant do next?
I walked with the defendant to his car to secure this identification.
What was the name on that ID card that you mentioned?
It said Tommy Williams.
Right, I'm going to write two IDs on the Williams. After the defendant told you his name is Tommy Williams and gave you an ID with the name Tommy Williams, what did you ask him next?
I was there for a call and I wanted to do some investigation. So I asked him if I could, if he would sign a waiver so I could search the apartment.
How did the defendant respond to this?
He said he would, and he signed the waiver as Tommy Williams.
I'm going to write 3 signs Tommy Williams. Your Honor, we plan to continue building this chart with the next witness. Maybe we preserve it at this time without understanding.
yes.
So Officer Perez, when you initiated this search, when you first went into the apartment, what did you see?
I saw a very dirty apartment. I saw a makeshift bed on the floor, a table in the dark, and then a stairway going upstairs.
Did you notice whether or not there were any kids in danger on the first floor?
I didn't see any children on the first floor.
So what did you do next?
I decided to go to the second floor.
When you got to the second floor, where did you go?
I went to a bedroom. I turned left and went into a bedroom, and that's where I went.
Your Honor, at this point, we plan to get into the testimony about Exhibit 6. Maybe you probably approach.
Yes.
Your Honor, Exhibit 6 is a photograph of a bedroom that depicts the gun. Again, for the reasons we urged in pretrial, the gun is relevant to a narcotics investigation. Again, Your Honor, multiple circuits have held that guns in narcotics investigations are relevant, and they're relevant to the intent to distribute portion of this. It goes to show that there's more than your possession in mind because there was a firearm, which intent to distribute is one of our elements that we must prove today. And for that reason, Exhibit 6 should be admitted.
Your Honor, may I respond?
Yes, you may.
We were quoted a lot of cases from different circuits, and what I can tell you is there's a likely distinction between those cases and this one, and that's that this gun was not collected. So the claim by the state that this gun was relevant, it was simply left exactly where it was found. There was no full serial number, no attempt to find where it was bought, or any attempt whatsoever to find out that it actually belonged to the defendant. And therefore, if it was the defendant's gun, we would agree there would be relevance, but the state did absolutely nothing. In fact, left the gun there to be disposed of. And because of that, Mr. Williams has no ability to defend himself from that piece of evidence that was left at the scene.
This was presented as the defendant's motion in limine, correct?
Yes, sir.
That motion is granted.
Your Honor, so is Exhibit 6 excluded?
It is excluded.
Yes, Your Honor. So Officer Perez, when you got into the bedroom, what was one of the first things that you noticed on the counter?
On the counter,
Or excuse me, on the dresser, my apologies.
on the dresser, I saw bags with white powdery substances.
And did you notice anything else on the floor, near the dresser, anything else in your investigation?
Yes, I saw 3 flip phones on the floor in front of that counter with the powdery substances.
And so Officer Perez, what did you do when you found these bags of white powdery substance in the same room as you saw these flip phones?
I took the powdery substances downstairs. I had left my backup officer downstairs, and placed those bags on the table that I had mentioned earlier.
Officer Perez, did you photograph those bags of white powdery substance where you found them?
I didn't know.
Why not?
I'm not sure. I don't have an answer for that.
Officer Perez, when you took those bags downstairs, transporting that key evidence, was wearing gloves?
No,
Why not?
I didn't think of it. I don't have an answer for that.
So you said that you transported it downstairs. Where did you take those 2 bags?
But like I mentioned earlier, I set them on that dinner table that I had seen when I came in.
Your Honor, maybe show the jury what's been pre-admitted as Exhibit 8 pre-trial.
You may.
Perez, can you remind the members of the jury what we're looking at here?
Yes, I took those bags downstairs and put them on the table, and that's when I discovered a series of scales and other tools that I knew to be related to drugs and narcotics.
Yeah, so Perez, I just want to make something clear with members of the jury. Did you find those 2 bags of cocaine as they appear in that photograph?
No, I had brought them.
Okay, so I want to go through a few items in this photograph specifically, so I'm going to circle them and then we'll talk about each item. First of all, Officer Perez, what is this?
That is a bag of white substance.
Okay, what's this smaller one?
That is a smaller bag of that white substance.
Okay, then what about this item that is underneath the bag?
That's a scale.
Okay, and it's kind of hard to see off to the left, but what are those turquoise smaller items?
Those were a series of turquoise bags underneath the drugs that I had found.
Officer Perez, isn't it true that you found those bags on the kitchen table?
Yes, yes. A lot of this was on the kitchen table when I approached.
What was the only thing that you found upstairs?
The bag of cocaine.
Okay. And Officer Perez, I'm going to circle one more item. I guess 2 items technically. What are these?
These are weighing and cutting tools that I had found on the kitchen table.
Isn't it true that they are straws?
Yes,
Officer Perez, while you had all of these items assembled together, did you call the crime scene unit to come and fingerprint any of this key evidence?
I did not know.
Why not?
It would have taken them all night to arrive. I had a third backup officer, in fact, a detective on the way, and so I didn't call the crime scene investigation unit because it would have taken all night for them to arrive.
Take that. Officer Perez, I want to make one thing clear. When you first arrived at that apartment, who else was in that apartment?
No,
Ask this.
Cross-examination, please proceed.
Good afternoon, officer.
good afternoon, sir.
Testified just a moment ago that you're with McKinney PD.
I am, yes.
Joining McKinney PD, you had to go to the police academy.
I did, yes.
It's at the police academy that they show you how to be a good officer.
Yes,
They train you.
yes,
Part of that training is how to protect the integrity of the crime scene,
yes,
how to protect the integrity of the evidence out of that crime scene.
yes,
It's also true that that training is very important.
it is.
It's important to follow every time.
It is, yes.
And in fact, if you don't follow that training, an innocent man could go to jail.
That's a possibility.
Go to July 30th, 2020, where you were called to 202 Red Bud. When you were called there, you were called for a child endangerment, right?
Yes,
And because it was an urgent call, turn on your lights and sirens and head there as quick as you could.
I did, yes.
Because every second that a child's life is in danger matters, right?
Yes,
There was a particular apartment you dispatched to 202, right?
I don't believe so.
So you arrived there pretty quickly.
I did, yes.
While you were waiting for backup to arrive, you didn't do any search for any children, right?
No, I waited for my backup.
Now, when you were in your car, did you drive around looking for any signs of children that might be in danger?
No, I waited for my backup.
There was an additional note that came in about that call, saying that drugs might be being sold in front of children.
Yes,
So fair to say this was a search for endangered children,
yes,
and it was also a search for potential drug activity.
yes.
Now, when backup arrived, you still didn't do any search for any endangered children, did you?
We approached the apartment.
You approached apartment 123.
Yes,
There were no signs of any children outside of apartment 123.
No.
You didn't do any search for signs of children from any other apartments.
no.
You just picked
Number 123, yes.
them. When you knocked on the door to apartment 123, Mr. Williams answered the door,
Yes,
and you didn't hear any sounds of children inside.
No.
You didn't see any children inside.
not from what I could see from the doorway.
Now, you told Mr. Williams at that point that children were being held against their will.
Yes,
That was a lie, wasn't it, Officer Perez?
it, per the calls and per the information that I heard, that's what I understood the issues to be, an issue of drugs and children. And that's what I told the defendant.
Let's go over that. So I want to make sure we're clear. Your call wasn't that children were being held against their will,
It was a child endangerment call.
but you made up the detail that you told Mr. Williams.
Yes,
You lied.
I shared with him what I believed to be the call to be about and the information as I knew it.
So your testimony is that you believe children were being held against their will.
I understood that children had drug paraphernalia managed in front of them, and I was against their will.
So is that a yes?
Yes,
But you have no reason to believe, other than the child endangerment call, that those children were being held against their will.
yes,
Well, upon telling Mr. Williams that, he consented to the search,
he did, yes.
and you began that search.
I did,
You entered the apartment,
yes,
you started on the downstairs.
yes,
You're searching at this point for endangered children and drug activity.
Yes.
You don't see any evidence of either of those things.
No, not at first.
So then you headed upstairs.
I did.
And when you get to the top of the stairs, there's a bathroom, right?
There is.
You go right past.
It was in front of me, and then the bedroom is to the left.
But
So-
you don't go into the bathroom.
I don't know.
You don't pull aside the shower curtain.
No,
You don't look in the cabinets.
No.
Fair to say you never entered the bathroom.
I didn't. No.
So you go into the bedroom. You go in there, the lights are off.
Yes,
Now, at some point, you turn the lights on, right?
I do.
That's when you see 2 bags of cocaine sitting on the nightstand.
I do. Yes.
Now, this would have been a good time to call the forensics unit, right?
Yes.
But you didn't do that.
No,
It's a violation of police procedures. And
I believe so.
now, then you walked over to the cocaine and grabbed it with your bare hands.
I did.
That's a violation of police procedures. And
I believe so.
then you took those bags of cocaine and you moved them from where they were found downstairs.
I did.
That's a violation of police procedures. And
I believe so.
And then later, when you photographed those bags, you photographed them in a place they weren't found.
Yes,
Isn't that also a violation of police procedure?
I believe so.
Now, fair to say, after you grabbed that cocaine and left the room, you were done looking through the
I didn't return to the bedroom.
You forgot something, didn't you? Also?
I don't believe so.
You forgot the closet.
I didn't hear any signs of children. The door to the bathroom was open and I had found a drug paraphernalia, so I went back downstairs.
But you didn't search the closet.
No,
Endangered children could have been there.
perhaps, yes.
Tommy Williams could have been
Perhaps,
there. Anyone could have been in that closet.
yes.
You were asked a question a moment ago. Mr. Williams was the only person in this apartment.
Yes,
You don't know the answer to that question, do you?
he was the only person I saw in that apartment.
But you didn't look in the closet, right?
I didn't check the closet adjacent to the bedroom.
And you didn't check the shower in the bathroom.
Objection, Your Honor, repetitive.
Move along, Mr. President.
Yes, sir. You took the cocaine downstairs and you put it on the table.
I did.
Threw it on the table.
I placed it on the table.
You placed it
Yes,
carefully.
believe so.
You placed the big bag carefully next to the scale.
I placed it on the table.
And then you placed the smaller bag right on top of the scale, right?
Yes,
Set the scene.
I put the evidence on the table so me and my accompanying officer could review it.
Then later you went and got a camera.
Yes,
You didn't bring the cocaine back upstairs.
no,
To photograph it where you found it.
No.
Instead, you chose to photograph it just like you placed it on the table.
yes,
And you talked about these turquoise bags a moment ago. You didn't collect those in evidence, did you?
no,
And the scale that you said was important for weighing out drugs, you didn't collect that either.
no, we didn't bring it with us.
Now, these straws, you never collected those in evidence?
No,
That's not all the evidence you left at the scene, is it?
I'm not sure.
Well, we heard you testify that there were phones upstairs, right?
Yes,
You didn't collect those phones in evidence.
no,
And in fact, upstairs while you were there were pills strewn about the floor, right?
yes,
You didn't collect those either?
No.
And in fact, on the nightstand upstairs, right next to where you found the cocaine, there was a prescription pill bottle
yes,
with a label.
I believe so.
You didn't check to read the label,
I'm not sure.
so we don't know whose name is on that pill bottle.
I'm not sure.
We don't know if there's more illegal drugs inside the pill bottle.
I'm not sure.
You didn't collect any of that stuff upstairs in evidence.
I don't believe so.
Now, it's at this point, you decided to call Detective Giddings.
Yes,
Fair to say, when Detective Giddings showed up, he took over.
yes,
It took about an hour for him to arrive, right?
I'm not sure.
More or less.
I'm not sure I could tell you, maybe around that time.
Well, however long it was, at no point during that time did
Did you search for any endangered children?
No, I saw no signs of children in the apartment.
Fair to say, anything else we want to know about this investigation? We need to talk to the secretary.
I'm not sure.
Well, Officer President, you don't have any more to tell us about this investigation, do you?
I don't believe I can speak freely, but I can answer any questions provided to me.
Well, Detective Giddings arrived on the scene, right?
Yes,
And at that point, he took over.
yes,
So anything else about that investigation, we would need to talk to Detective Giddings.
I believe so, yes.
What other questions are?
No redirect, Your Honor. I just asked that Officer Perez be excused.
You may be excused.
Thank you.
Your Honor, at this time, we call Detective Ash Giddings to the stand.
Okay,
Your Honor, before we begin, may I set the courtroom?
of course.
Your Honor, the court's attention, we are switching from this, from the Elmo to the mobile laptop view.
Your permission to review my.
Yes, you may.
May I proceed?
Yes, you may.
Good afternoon. Could you please state your name for the members of the jury?
Yes, I'm Officer Ash Giddings.
What do you do for a living?
I'm a detective in the Narcotics Division at Virginia Police Department.
Detective Giddings, how long have you worked in law enforcement?
I've worked in law enforcement about 20 years now.
20 years of experience. How much of that time have you spent doing narcotics?
It's going on about 5 years.
So as a narcotics detective, what exactly is the focus of your job?
My focus of the job is to assist patrol officers with narcotics arrests, investigate sales and distribution of narcotics, and assign to overdose cases as well.
As part of your experience and training, are you taught to identify what narcotics looks like?
Yes, I am.
Well, I want to now talk about the investigation you conducted for this case, the one you did on July 30th of 2020. Do you remember what you were called for that day?
Yes, I do remember what it's called.
Where were you called to?
I was called to the Red Bud Apartments.
And what were you called there for?
I was called because the patrol officers that were there found narcotics.
And so when you arrived at the scene that day, had the patrol officers found anything they believed to be evidence of narcotics, illegal drug use, or illegal drug distribution?
Yes, they did.
Your Honor, maybe show the jury exhibit 8. It's already been admitted.
Yes, you may.
All right, at Giddings, the jury is now looking at exhibit 8. Just generally, what exactly is this picture?
So in this picture is going to be the items that were found in the scene that links to show that it could be part of drug use and distribution of drugs.
Let's get into what we see there. First, though, just who collected this evidence?
It was the officers that was there prior to I was called, and one of those officers was Officer Broyles.
Do you have any criticisms of the way they collected this evidence?
Yes, I do.
What exactly are those criticisms?
Well, as a police officer, you should not touch the items prior to taking pictures of where you found it, and that happened in this case.
So if they were following proper procedure, where should they have taken a picture?
The picture should have been taken where these items were initially found, or the drugs were initially found, which was upstairs.
Architect things. Now I want to talk about some specific things now. So let's talk about those 2 baggies with a white powdery substance inside. Did you ever send those off for testing to confirm what was inside?
Yes, I did.
Your Honor, maybe show the jury exhibit 1. It's already been pre-admitted.
You may.
This is the first time the jury's seeing this exhibit, so can you describe what is exhibit 1?
So exhibit 1 is the drug analysis laboratory report of those drugs that I sent in that was found on that table.
Let's have the results. So I'm going to zoom in there real quick. Detective Giddings, what was the result of the first bag that you submitted, that you sent out for testing?
The result of the first bag is that it had 1.34 grams of cocaine.
What about that second bag?
The second bag had 1.21 grams of cocaine.
So all in total, how much cocaine was found in apartment 123 on July 30th of 2020?
2.55 grams.
We can take that down to exhibit 1. And I want to now look back at exhibit 8, Detective Giddings. Staying on those 2 bags of what we now know is cocaine, did you ever fingerprint those 2 bags?
No, I did not.
Turn to the jury, explain to them why you didn't do it.
We didn't fingerprint those bags because I did find out Officer Perez had touched them without having gloves on from downstairs, so it would have his fingerprints on it as well.
What are the rest of the things that you see in exhibit 8? Did you fingerprint any of that?
No, we did not.
Again, can you turn to the jury and explain to them why?
We didn't fingerprint any of those items because we felt it wasn't necessary to fingerprint that.
All right, Detective Giddings. Now, I want to talk about some specific items and how they were important for your investigation. So I'm going to circle a few things and tell me if they were important or not for your investigation. The first thing is that digital scale. Was that significant at all for your investigation?
Yes, it was.
Why?
The scale in this situation, since it was along with the drugs, does show that it could be used to measure the actual cocaine itself and put it into smaller baggies for distribution.
Okay, it's hard to see in this picture, but there's turquoise baggies up to the left. I'm going to circle those real quick. Were those significant to your investigation?
Yes, they were.
How?
Just like I stated, the scales used to measure down for distribution into smaller baggies, and those are the baggies that are known to have the cocaine inside to be distributed.
And the final thing that I'm going to circle is the 2 bags of cocaine. The fact that they're different in size, is that at all significant for your investigation?
Yes, it was.
How is the fact that they were different in size significant?
In the drug operation business, typically the bigger bag has the larger quantity of cocaine. And since there are purchasers of this cocaine, and typically they all buy smaller quantities, that's what's in the bigger bag. Those smaller bags is what's used to put the cocaine from the bigger bag into to sell.
All right, Detective Giddings, well, after you reviewed all this evidence that we see here, what did you do in regards to the defendant?
Well, after reviewing this evidence, that's when I arrested the defendant.
Detective Giddings, before you placed the defendant in arrest, did you ever ask him what his name was?
Yes, I did.
And when you did, how did you respond?
That his name is Tommy Williams.
Your Honor, permission to approach a chart?
Yes.
All right, Detective Giddings, now we've been keeping track of some of the things that the defendant told law enforcement on July 30th of 2020. You just told us that when you asked him his name, he said Tommy Williams.
That's correct.
So I'm going to write up here full name Tommy Williams. Your Honor, may we approach it this time?
You may.
Constructively? Your Honor, at this point in time, we do plan on going to the moment where the Detective Giddings transported the defendant to jail. And at that point, the defendant admitted that cocaine found in that apartment was his. I believe opposing counsel brought it up during opposing counsel reserved rulings.
Yes.
So we'd like to ask for admissibility at this point. And Your Honor, specifically the admissibility of 2 separate items. First, the initial questions that were raised by the defendant in the back of the cop car. When nothing was asked of him, he voluntarily brought up the statements, how can I get out of jail? How can I avoid getting out of this? And then additionally, the confession that came after the detective made him an offer, he said, I can't do that. I own 3 drug dealers. That was found, that cocaine was mine for personal use.
What is your response?
Your Honor, under Rhode Island versus Ennis, the Supreme Court of the United States has said and defined what a custodial interrogation is. And that is any words or actions on part of the officer that is reasonably likely to elicit an incriminating response. In this case, the officer offered Mr. Williams a deal. If you can do 3 controlled buys, then I will ignore these charges. It's inherent in the question. The answers could be yes or no. Yes, being a possible answer would be an incriminating response, because had this conversation actually happened and Mr. Williams had said yes, that would mean that Mr. Williams was admittedly engaging in criminal activity and telling the officer that he was engaged in deception. Therefore, that question was custodial interrogation. Mr. Williams was not Mirandized by an officer with 20 years of experience. He should have been recognized.
But it's Mr. Williams who initiated the conversation. Is that correct?
Yes, Your Honor, he's the one who initiated the conversation by asking the questions. How can I avoid this? How can I avoid going to jail?
But he was not Mirandized when he initiated the conversation. I will grant the motion in limine.
Your Honor, just to be clear, does this motion go specifically both to the questions that were asked initially before the detective ever responded and the confession?
It does.
Yes, Your Honor. Detective Giddings, you told us a moment ago that you placed the defendant under arrest. And I want to talk about the moment that you arrived at the jail that day. What was the first thing that you did when you arrived there?
Once we arrived, I then booked Timmy Williams.
Did anything unusual happen during the booking process?
Yes, something unusual did happen.
What was that?
Like I said earlier, the defendant was telling me his name was Tommy Williams. And then during the booking process, we then took his fingerprints, and the fingerprints came back that he wasn't Tommy Williams.
So what did his fingerprints come back in favor of? What name?
The name came back as Timmy Williams.
How did you respond to this?
So that's when I approached Timmy Williams and said that your name isn't Tommy Williams, your name is Timmy Williams, correct? And then that's when he nodded his head.
So Detective Giddings, do you see Timmy Williams before you today?
Yes, I did.
Can you point him out for the members of the jury and identify him with an article of clothing?
Yes, that's Timmy Williams, and he's wearing a blue blazer.
Your Honor, may the record reflect that the witness has correctly identified Timmy Williams as the defendant in today's case?
The record will so reflect.
So Detective Giddings, now that we know who the defendant's name is in this case, I want to make something clear. When the defendant told Officer Perez that his name was Tommy Williams, was he telling the truth when he said that?
No, he was not.
Name an ID to the officer saying his name was Tommy Williams, was that his ID?
That was not his ID.
When he signed a legal document as his name is Tommy Williams, was he signing his own name?
He was not signing his own.
Finally, you told us a moment ago that when you asked him that day what his name was, he looked you in the eye and said Tommy Williams. When he said that, was he telling the truth?
He was not telling the truth.
Your Honor, we offer this as prosecution demonstrative aid 1.
That'll be admitted.
And with that, Your Honor, pass the witness.
All right.
Prosecution.
You may proceed.
Detective Giddings, you've been a narcotics officer for 5 years.
That's correct, yes.
And in those 5 years, you've received specialized training, right?
Yes,
In that training, some of that training was how to handle evidence on the scene.
that's correct.
Narcotics evidence is physical evidence, right?
Yes,
So there is a certain protocol for how you're supposed to handle it, right?
that's correct, yes.
Proper protocol would be to wear gloves before handling the evidence,
Correct,
and proper protocol would be leaving the evidence where it's found.
correct,
And proper protocol would be photographing that evidence again where it's found.
that's correct.
Now, I want to move forward to the evidence that's found on July 30th, 2020. All of that evidence found on the scene was also physical evidence.
Yes, it was.
I want to talk about what Officer Perez did on the scene that day. You mentioned on direct that you had some criticisms, correct?
I did.
Officer Perez made several mistakes that day.
Yes,
The first mistake that Officer Perez made was touching the evidence upstairs with her bare hands.
yes,
And the second mistake was moving that evidence downstairs.
yes.
And the third mistake was taking a picture of it downstairs and not upstairs, right?
That's correct.
You mentioned on direct examination that Officer Perez touching the bags upstairs prevented you from investigating who could have touched those bags, right?
That's correct.
You weren't able to fingerprint
I wasn't able to fingerprint, that's right.
because Officer Perez's fingerprints would be all over those bags.
That's correct.
So we'll never know who actually touched the bags down upstairs.
I mean, not through fingerprints.
We'll never know. We'll never know conclusively who other than Officer Perez touched those bags.
Not through a laboratory report.
Giddings, you mentioned that downstairs there were some items that you saw on a kitchen table, right?
That's correct.
You mentioned that all of these items have a specific meaning, right?
They do.
And they all affected your investigation.
Yes. Well, what do you mean by that?
They informed you on what was proper to charge, correct?
Oh, that's correct. Yes.
I'm going to show you what has been pre-admitted to Exhibit A. I want to talk about the items that were found on this table. You said that the baggies on the left-hand side, those were significant because they were used for packaging, right?
Yes,
And then the scale was significant because it would be used to weigh out the drugs.
that's correct.
And the straws are significant because it would be used for ingestion.
I never mentioned that, but yes, they can be.
Detective Giddings, you never collected the straws, correct?
No, the straws aren't collected.
You didn't collect the scale.
No, I just collected the drugs.
You didn't collect the turquoise bags.
No, I didn't.
So you didn't run any residue analysis on the bags.
No, we don't have an analysis of the residue of the baggies.
And you don't know if there was ever any cocaine on the scale either.
The picture shows cocaine in the scale.
Right, but that's because Officer Perez placed it on the scale, isn't that right?
I just know you placed it on the table. I don't know about putting it on the scale. I'm sure.
Well, to your knowledge, this is where Officer Perez placed the bags on the table, right?
I know you placed it downstairs. Yes.
You know who placed them on this table.
Yes,
And to your knowledge, these items, the two baggies, this is where Officer Perez placed them.
like I said, I don't know if you put the bag on the scale, but I know you put the drugs on the table.
You know, when you walked in the door that day, that's what it was found.
That's how I saw it.
That's how you saw it.
Correct.
You didn't check these straws to see if they were being used for cocaine purposes, right?
No, the straws weren't checked.
Yet you determined that all of these items were indicative of intent to deliver.
They are, yes.
Detective Giddings, that you didn't arrest Mr. Williams for possession with intent to deliver, right?
What do you mean by that?
On July 30th, 2020, you arrested Mr. Williams for possession.
That's correct. Yes, that's correct.
You didn't arrest him for possession with intent to deliver.
At the moment, no.
But Detective Giddings, isn't it true that the evidence that you have today is the same evidence that you had on July 30th, 2020?
Yes, but I only took the drugs.
For Detective Giddings, you're making a conclusion that Mr. Williams had intent to deliver, isn't that right?
Yes, but also keep in mind, I wasn't the only officer on the scene, so they also collected different evidence too.
I understand that. My question is not who collected the evidence. It's about your conclusions in the investigation. You are saying that Mr. Williams, based on the items on the table,
Mhm.
had an intent to deliver, right?
Yes.
But you didn't come to that same conclusion on July 30th, 2020.
Well, I would like them to keep in mind that we work as a team, so.
I understand that, but I'm asking you about your conclusion on July 30th, 2020. You only arrested him for possession, correct?
Well, yeah, that was my job that day, was to collect the drugs. So yes, possession.
You didn't have enough evidence to charge him with intent to deliver.
Objection, Your Honor, repetitious. This question's been asked multiple times.
Your Honor, the witness hasn't answered the question.
Please answer the question, sir.
Detective Giddings, you didn't have enough evidence on July 30th, 2020 to arrest Mr. Williams for intent to deliver.
No, I did not, me personally. No.
You didn't do any further investigation into who was living in apartment number 123.
Me personally, no.
You didn't go to the leasing office to ask to see the lease.
No, I think other officers were handling that.
You left with everything on that table other than the two bags, the officers who had already made mistakes.
Wait, what was the question?
Detective Giddings, on July 30th,
Uh-huh.
you only took the two bags, right?
Yes, I did.
And everything else that you say is evidence,
Uh-huh.
you didn't take it, right?
No, I did not.
You left that on the scene with Officer Perez and the other officers.
That's correct.
And those are the same officers that had already made mistakes.
Pre-handedly, they did.
Detective Giddings, you don't have anything that conclusively says Mr. Williams was living in apartment 123.
At this moment, I mean, no, I don't.
You just assumed that because Mr. Williams was there, he was the one who had possession.
That's correct. That's how drug operations work.
You didn't find the baggies on Mr. Williams, right?
No, he was just around.
You didn't find any cash on Mr. Williams either.
To my knowledge, no.
You just thought because he was in the apartment, he must have known that those items were upstairs.
I didn't think that I knew.
You knew that, 1,000% that Mr. Williams handled the baggies that were found upstairs.
From my investigation, yes.
The Detective Giddings, you don't know, right?
I'm not sure what you mean.
Well, you don't have fingerprints that show Mr. Williams touched those bags.
Well, during my 20 years of narcotics, fingerprints are not going to conclusively show all the time that they're the ones who did it. At times, it's going to be when someone gets caught red-handed, like in this case.
Detective Giddings, you're saying Mr. Williams was caught red-handed, yet you don't have anything tying him to that apartment, right?
Yes, he was there with the drugs.
Other than his presence, you don't have any evidence that he actually touched those bags.
Well, like I was saying, he was there with the drugs, so no.
You don't have anything linking him to the items on that table.
Besides him being there with the drugs,
Isn't it true that you don't know who was actually living in that apartment?
From this case, it looks like, well, I don't know what you mean by that question, actually.
Detective Giddings, you never yourself investigated who was actually living in apartment 123.
Yes, correct, I did.
So you don't know who was living there.
At that time, no.
Detective Giddings, you still don't know, right?
If I'm not mistaken, it was Tommy Williams' apartment.
It's Tommy Williams' apartment. That's Mr. Williams' brother, isn't that right?
Yeah, the ID that to me, that correct.
That's the person who was actually living in the apartment.
I'm not sure.
Detective Giddings, you just said that it was Tommy Williams' apartment, isn't that right?
That's who signed the papers, that's all I know.
That's the list.
Your Honor, may we constructively approach?
Yes, you may.
Your Honor, we understand that you're ruling regarding the alleged confession in today's case. However, at this point, we believe the circumstances have changed. As opposing counsel has extensively asked questions to Detective Giddings, asking him, will never conclusively know who actually touched those two baggies. You don't know who 100% handled those bags, as well as you have any evidence of who touched those bags. When the truth is, Your Honor, Detective Giddings does have that evidence. At this point, Your Honor, they've opened the door to go into the specific statement of that cocaine found in the apartment was mined for personal use. And so, Your Honor, we'd ask that we allow to go into that on redirect examination.
The argument is that by asking him questions, they've opened the door.
Yes, Your Honor, because they've said that this detective does not have any evidence to go to that regard. You will never know conclusively who actually touched that. But the detective does actually have that evidence, Your Honor. So opposing counsel is trying to attack the credibility of Detective Giddings at this point, when he actually does have that evidence.
Response?
Your Honor, that doesn't take away the fact that Mr. Williams' Fifth Amendment right was violated when that custodial interrogation occurred in the backseat of the car. It shouldn't come in because it's a violation of Mr. Williams' constitutional right. He should have been Mirandized. It's not his fault that that officer didn't do it.
Violation or not, if you open the door, it does allow them to get into it. I will allow you to get into that area.
Yes, Your Honor. And just to be clear for the record, Your Honor, which parts are we allowed to go into this conversation?
You are, well, to the extent that it responds to the door that she opened.
Yes, Your Honor. Detective Giddings, you were just asked a lot of questions about who touched the bags of cocaine that was found in apartment 123 on July 30th of 2020. So I want to talk to you a little bit more about that. Do you have any evidence of the defendant actually touching those bags?
Yes, I do.
What is that evidence?
Well, while we were taking the trip from the apartments, after I arrested him, we took a trip from the apartment to the police station. And while he was in the back of the car, he admitted to it.
He admitted, when you say he admitted to it, what exactly did the defendant admit when he was in the back of the car?
He said it was for personal use, relating to the drugs that were found.
Just to be clear, with all the confusion of names in today's case, what is the name of the person that admitted that that was his for personal use? Who's the one who admits that?
The defendant, Timmy Williams.
Ask the witness.
Do you have any recross? Please proceed.
Is that conversation that occurred in the backseat of the car. You didn't record that conversation, did you?
It's in my statement.
That's not what I'm asking. I'm asking if you put your dash cam or your body cam on Mr. Williams and recorded that conversation.
No, it was just too quick.
You didn't record it later either, right?
Later in my statement, yes.
You didn't write it down, right?
No, I didn't write it down.
And when you arrested Mr. Williams, you didn't tell him what the controlled substance he was arrested for, right?
I think he already knew, so no.
You think you already knew, but you don't know for sure because you didn't tell him.
I mean, no, I didn't tell him. To answer your question.
You just told him it was possession for a controlled substance.
Correct, which is a drug, which most people know.
Mr. Williams could have been referring to absolutely anything, right?
No, I don't think he was.
Well, direct beginnings, I'm asking you what you think. Mr. Williams didn't have any knowledge from you that he was arrested for possession of cocaine, right?
I mean, when someone admits that it was for personal use, I'm pretty sure they know what they're talking about because that's what the whole situation was about.
Pretty sure is not certainty, right?
Well, I'm certain he knew that he knew what he was talking about, yes.
That's just your opinion, though, right?
My 20 years of being a narcotics detective, correct, yes.
And at this point in time, when this conversation allegedly occurred, Mr. Williams was handcuffed, right?
Yes,
And he was in the backseat of your car.
that's correct.
He was on his way to jail,
That's correct.
and he wasn't allowed to leave.
He wasn't allowed to leave the car.
He wasn't allowed to leave your custody anymore.
That's correct.
And it was just you and Mr. Williams in that car.
That's correct.
That's the latest.
Your Honor, we would ask the detective, if we have no further questions, we would ask the detective Giddings to be allowed to be excused.
You may be excused, sir.
With that, Your Honor, state rests.
All right,
Maybe have a brief recess before we start the next case.
let's keep it real brief. Can we do 5 minutes?
Yes, Your Honor.
Yes, Your Honor. Thank you.
What? Why are you apologizing?
I don't know, it feels like. Mr. Raley, coffee's upstairs on 17, I'll walk through with you. How about that?
So I just did some. Just saw that. Or minus the jurors, so go ahead and have a seat.
Your Honor, Ms. Ventura.
Yes, we're not going to start until he returns.
Oh, okay, I did.
Sorry, it's hard to hear under this thing.
Yeah, I can't help. Then also someone else will drop you before listening.
John Raley, still coffee.
How about you just don't spill the coffee, John, and then I'll have to have a conversation with that drop.
Do well with liquids, everyone. No, this is highly improper. Can I place this right?
Of course. As long as you promise not to spill anymore. Are we ready, defense?
Your Honor, prior to beginning the case, we have a motion to make outside the presence of the jury.
Okay,
Under Federal Rule of Criminal Procedure, Rule 29, we now move for acquittal, as no reasonable jury could find the intent to deliver a portion of the crime that Mr. Williams has been accused of. At this point, the only evidence the state has put forward is that Mr. Williams was in the same room as items that Detective Giddings claim are associated with the intent to deliver element of the crime. However, we've heard from another officer who was in the same room actually searching for evidence for drug activity and didn't find it. Any assumption that Mr. Williams, simply because he was in the same room, not only interacted with those objects, but even knew they were there, at this point is not, no reasonable jury could infer that given the facts we heard from Officer Fritz.
that motion will be denied.
Yes, sir.
examination?
Please proceed.
The defense calls Jean Rispoli to the stand. Good afternoon.
Hello,
Will you please introduce yourself?
my name is Jean Rispoli.
Mr. Spoli, what do you do for a living?
Well, I own and run the 202 Redbud Street apartments here in McKinney.
How big are the Red Bud apartments?
The apartments themselves are pretty small and the complex is pretty small as well. I have 24 units, but I'm only leasing out 22.
What do you do with the other 2 units?
Well, I live in one of them and then the other one serves as my office.
Mr. Spoli, I want to talk about how you are as a landlord. How would you describe yourself?
I would say I'm a pretty no-nonsense gal. You know, this is my living. This is how I make my money. And so business is my priority.
Are there any requirements that you have of people who are potential tenants?
Yes, I always ask for a copy of identification, such as a driver's license. I get 2 contact phone numbers in case of an emergency, and then I usually get some references.
Now, I want to talk about a specific apartment. Do you recall who you're releasing apartment 123?
In 2020,
Yes.
I was leasing apartment 123 to a couple.
Who was that?
The couple was Tommy Williams and Jennifer Williams.
Do I have permission to request this?
You may.
Hiring to the council, there's the 3 residents exhibit. No. The court like copy?
I believe I have one. Thank you.
Well, do you recognize this?
I do.
What is it?
This is a copy of the residential lease that I gave that couple.
Who made it?
I made it. I do that for all my tenants.
Was it made at or near the time by someone with personal knowledge?
Yes, when they came in, this is when we made this.
And is leasing apartments something that you regularly do when conducting your business?
I do, you know, and keeping a copy of the lease itself is also something I do.
So keeping the lease is something that you regularly do to keep track of this.
That's correct.
That's obviously different than no objection, Your Honor.
That'll be admitted.
Permission to publish the.
You may.
I want to walk through this exhibit here. What date was that exhibit? Was the lease signed?
So Jennifer and Tommy came in December of 2019.
What is the name on this list?
Tommy Williams and Jennifer Williams.
We look further down where it says occupants other than tenants. Is there anybody listed there?
No,
When the lease was signed, where were you?
I believe we were in my office.
And Mr. Williams, Tommy Williams, provided you with an ID.
Yes, I saw a copy of his identification. He gave also his social security number and he signed the lease.
What about references?
I got some references. I believe those were for Jennifer, but I did get some references as to the previous apartment.
Now, if we turn to the last page. Mr. Spoli, who signed the lease?
I signed the lease as well as Tommy.
And what other identifying information do you have on the lease for Tommy Williams?
The social security number that he provided me is on the lease in addition to the driver license number.
Mr. Spoli, I want to talk about now how Jennifer and Tommy were as tenants. How would you describe them?
They were pretty low key. I don't keep tabs on my tenants, you know, I'm just in charge once they pay the rent. But I didn't really hear from them much at all. I can't remember them filing any complaints or anything like that.
Is it odd that you didn't see Tommy and Jennifer around?
Not really. Again, I'm not a hall monitor. I don't keep tabs on my tenants. So long as the rent is paid, that's really all I care about.
I want to talk a little more about that rent. How often do they pay rent?
Well, rent was due on the 1st of every month. In particular, apartment 123, I do remember them paying usually on the 2nd. When I get to the office, that's when the money was usually there. So, but That was fine.
And how would they pay that rent?
Cash.
Ms. Foley, are you supposed to accept cash for your rent?
I believe the lease said we were going to do it a different way, but that's just how Tommy paid, and business is business. So as long as I'm getting paid, that's fine.
Let's move forward now, and I want to talk about July 30th, 2020. Do you remember that day?
I do.
What do you remember?
Well, it was a normal day, but up until sometime in the afternoon, I think it was, I saw some squad cars, and this is something new to me. So I did take a peek out my window, and I saw a man talking to the police.
Who was that man?
Well, I couldn't tell exactly now today, but I believed it was Tommy.
Was it actually Tommy?
No, I now know it was Timmy.
And how do you know that?
Well, I was subpoenaed to be here, and that's when I learned everything.
Mr. Foley, you mentioned that you saw some police officers there that day. Did any of those officers contact you about police living in apartment 120?
No, no one came to talk to me about it. No.
What about Officer Perez? Did Officer Perez ask to see the lease for apartment number 123?
No, I don't know who that is.
The officer who was. Now, Mr. Foley, what about a detective? Did a detective come and ask you about the lease?
No, and no one came to talk to me. I don't know anyone.
What about in the 500 days between July 30th, 2020 and today? Has anyone ever asked you anything about apartment number 123?
I believe one of the investigators tried to talk to me a little bit before, but I thought that was improper, so I didn't answer any questions until today.
Why did you wait until today?
Well, because I mean, like, I have a business to tend to, and this is time away from my business, and so I just wanted to get it all over with and not have to answer questions from multiple people.
Cross-examination, Your Honor.
Please proceed.
Before I begin, may I set up the courtroom?
You may.
Petitioner, Your Honor, maybe switch from the document camera to the Zoom camera.
Yes.
Good afternoon, Ms. Rispoli. I want to start by talking to you about who you believe was renting apartment 123 back in 2020.
Sure,
On direct examination, you testified you believe that was a person by the name of Tommy Williams.
that's correct.
The man named Tommy Williams came into your office in December of 2019 to rent unit 123.
Yes, with his partner, Jennifer Williams.
At some point before he signed that lease in December of 2019, he told you his name was Tommy Williams, right?
Right, I saw his driver's license.
When somebody, we'll get to that in a moment, but you'd agree with me that when somebody tells you that their name, it's reasonable to believe it's their own name, right?
Yes,
Not somebody else's name.
no,
So when he told you his name was Tommy Williams, you believed it.
that's true.
And not only that, like you mentioned earlier, you also get driver's licenses as part of your leasing process, right?
I looked at his driver's license, that's true.
And that driver's license had the name Tommy Williams on it.
I believe so.
Then it is riskfully, it's reasonable to believe that when someone hands you a driver's license with a name on it, that's their own name, right?
Right, everything matched up.
Again, not someone else's name.
On the driver's license?
Yes,
Right, yeah, everything matched up to Tommy Williams.
so you believe.
Yes,
Now, he also signed that lease back in December of 2019, right?
that's correct.
He signed the lease with the name Tommy Williams.
Yes,
And it's reasonable to believe that when someone signs a legal document, they're signing their own name, right?
yes.
So you had no reason to question this.
Again, no, everything matched up, so I believed it was Tommy Williams.
Ms. Rispoli, because he told you his name was Tommy Williams, handed you an ID with the name Tommy Williams on it, and he signed that lease, Tommy Williams, that's why you believe the man renting apartment 123 was named Tommy Williams.
Yes, I believe I already answered that, yes.
Ms. Briscoe, I'd like to talk to you a little bit more about that lease that you talked about on direct examination. Your Honor, maybe create a timeline throughout this witness testimony.
You may.
So, Ms. Briscoe, this lease, it began on January 1st of 2020, right?
Yes,
So we're gonna add January 1st, 2020, lease began. And the lease ended on December 31st, correct?
yes,
So we're gonna add December 31st, 2020. As you talked about on direct, you saw someone being arrested at the Red Bud apartment complex on July 30th.
that's true.
So we're gonna add arrest July 30th. Okay, now, Ms. Risley, I want to break this up into two separate time periods. We'll start with the first one between January and July 30th of 2020. During that time period, the person renting apartment 123 always paid rent, correct? Every single month,
To my knowledge, yes,
$750,
yes.
and he always paid it in cash.
Yes, the tenants of 123 would pay in cash.
They paid in cash every single month, right?
Yes,
And they only ever paid in cash.
I believe that's true.
So we're gonna fill in the area between January and July in green to show that Ms. Risley was receiving rent for 123 every month.
Okay,
Now I want to talk to you about what happened after the day that you saw the defendant being arrested. You never received August rent, right? For apartment 123.
no, I didn't.
And so you had to eventually, you tried to call Tommy and Jennifer Williams, the phone number that you have for them,
I did,
but nobody answered.
that's true.
And you never received a call from Tommy or Jennifer Williams.
Not to my knowledge.
So you eventually had to evict these tenants at 123.
Yes, that's true.
And when you went in to evict these people, there was still a lot of stuff in the apartment, right?
I believe there was some stuff I had to auction off, yes.
Yes, you had to auction off what you could and you threw away the rest.
And that was 2 years ago, so I can't remember, but that sounds like something I would do, yeah.
Ms. Risley, after you didn't receive rent for August of 2020, you never saw the person you believed to be Tommy Williams again.
Never saw Tommy and Jennifer, that's correct.
You never heard from the person you knew was Tommy Williams again.
Not to my knowledge.
So we're gonna fill in the area after the defendant was arrested and before the lease ends. We're gonna fill that period in with red to show that Ms. Risley never heard from, saw, or received rent from the person she knew as Tommy Williams. Your Honor, we offer this as prosecution demonstrative too.
That'll be admitted.
We can take down that. Ms. Risley, I want to talk to you a little bit more about July 30th, 2020. You said that you were working at the Red Bud apartment complex that day, right?
Yes, I lived there and I managed the same complex where I live.
You saw the police show up at one point.
Yes.
You saw this all through your window, right?
Yes, because I was, yes,
You saw the police talking to a man in the parking lot.
that's true.
That man you believed was Tommy Williams.
At the time, yes, he looked like Tommy.
So on July 30th, 2020, when you saw the police talking to the defendant, you believed that that was Tommy Williams. Objection, asked and answered.
Move along, please.
You believe that that was the same Tommy Williams who came into your leasing office back in December of 2019, right?
The person that I saw in the parking lot?
Yes.
Yes, I like I said, I thought it was Tommy.
The same Tommy Williams who only ever paid rent.
Again, I thought it was Tommy.
The same Tommy Williams who you never saw, heard from, or received rent from again after the day that the defendant was arrested. Objection, asked and answered.
Please move along.
Ms. Risley, the person that you saw in that parking lot that day, you believe that that was Tommy Williams. Objection, asked and answered.
Yes, yeah, I thought it was Tommy Williams, the same one that came in and signed everything.
Pass the witness. Your Director.
Yes, please.
Mr. Scully. How many
times did you try to call Tommy and Jennifer Williams?
At least once.
Why didn't you try to call them anymore?
You know, I'm leasing 22 apartments out. You know, if I have to keep tabs of everybody, where everybody is, that's time out of my day. I called once, they didn't answer. I move on with my life.
Mr. Spalding, who does Mr. Williams look like to you?
Which one?
Tammy Williams.
It looks like Tommy.
Ask the witness, Your Honor. We ask this witness.
Okay. You may be excused.
Thank you, Your Honor.
The defense calls Timmy Williams to testify. Good afternoon, Mr. Williams.
Good afternoon.
Please introduce yourself for us.
Good afternoon. My name is Timmy Williams.
And where are you from?
Well, I'm from right here. I live on a ranch currently about 30 miles out, where I work as a ranch hand.
Have any children?
I do. I have 5 kids.
Any other family in here?
I do. I have a twin brother and a sister-in-law.
Do they have any children?
Yes, they have 2 children, so I guess I'm an uncle.
Now, I want to go back to July 30th, 2020. Changed since then, but back then, what were you doing for work?
Back then, I was working at a KFC part-time, and then I was working as the ranch hand.
Where were you living?
I was living on the ranch. We had a deal where I could stay there as long as I was doing some work there.
What's the name of the owner of the ranch where you were living?
His name was Rick Carlton.
Clint Harbor, sound right?
Clint Harberson.
Now, Mr. Williams, how far away was your home on this ranch from your brother and Jennifer's farm?
It was 30 miles out of town.
Well, let's go to July 30th. I'd like to start on that day when your day started. Where did you wake up?
Well, that day I woke up on the ranch. It was a hot day that day.
What did you want to do then?
Well, I wanted to go out to the lake. I knew my brother lived nearby, so I decided to drive out over there.
Did you have any set plans for your brother that day?
We did make plans. I eventually went to the apartment to, see how he was doing, see how his wife was doing, spend some time with them.
Got there, what did you learn?
Well, when I got there, it turned out that they were about to head out for the day. They were going to leave for a couple hours.
When you found out they were going to leave, what did you do?
Well, when I found out that they were going to head out, I just driven 30 miles out there, so I figured I would just stick around. I asked if I could stay at their apartment while they were gone until they returned.
Did they let you?
They did, yeah.
So as you passed these couple hours and waited for their return, what did you do?
I just kind of hung out. I turned on the TV, started watching some TV. It was getting pretty hot, so I took my shirt off to cool down and eventually fell asleep on the mattress.
Did you ever wake up from that nap? Or what woke you up from that nap?
I woke up to a knock on the door.
Did you answer it?
I did.
Who was it?
It was the police, the McKinney Police Department.
You were surprised.
I wasn't expecting the police, so yes.
When you saw those officers, what did they tell you they were there?
They told me that they were there for some child abuse that was going on.
Now, this thing they tell you about the children, how did you react?
I mean, I was confused. I was shocked that there were no kids in the apartment, so I don't understand what they were talking about.
At any point, did the police officers ask you to identify yourself?
They asked me for an ID, yes.
And what ID did you give?
Well, I gave them my brother's ID.
Say, why would you do that?
Well, the truth is, I was on probation because of theft. I stole some beers from a local store, and I just couldn't afford to go see the probation officer anymore, so I stopped showing up. And I was afraid that they were there because of that.
What were you doing to try to get caught up on this probation?
Well, I was working. I was trying to make some money, you know. It was tough, you know, all those fees started piling up. I didn't have any work at the time, so I was trying to dig myself out.
And you just mentioned you didn't have any work. How many jobs did you have at the time?
Well, I had two when the officers arrived.
So once the officers take this ID that you gave, your brother's ID, what did they do next?
Well, he ran my brother's ID, and then he told me that there were warrants out for him.
React to that.
I was terrified. You know, the whole point was, you know, I didn't want to get in trouble for the probation violation, and turned out that I might get in trouble for it anyway.
While you're feeling all this, what did the officers tell you?
Well, you know, he offered me a deal. He told me that if I let him search the apartment for children, he would look the other way.
Did you consent to this?
Well, of course, there were no children in the apartment, so I consented.
Mr. Williams, what did they find inside the apartment?
They didn't find children, they found drugs.
Now, where did they find this drug?
They found it in Tommy and Jennifer's bedroom upstairs.
Did you ever been in that bedroom?
No, Tommy, you know, tells me to stay down on the first floor, and so I do.
Were you aware of any drugs that were in the bedroom?
I had no idea what was in that bedroom.
Did you ever touch the drugs that were found?
No,
Were you aware that your brother did cocaine?
I was aware that he did cocaine, yes.
Mr. Williams, heard some testimony about some items that were scattered around the table, the scale, some bags, some straws. Did you ever see and notice those items on the table?
No, Tommy's apartment's a mess. You know, there's so much stuff thrown around. It'd be impossible to keep inventory of what was in that apartment.
Mr. Williams, why did you let the police search Tommy and Jennifer's apartment?
I didn't think there was going to be anything in the apartment. You know, I didn't know Tommy had drugs upstairs.
That's the concern.
Okay, Ross?
Yes, Ron. Before I begin, we gotta set up the board.
Yes.
MC?
Please.
Mr. Williams, I want to start by making something clear for the members of the jury. Your name is Timmy Williams, right?
Yes, it is Timmy Williams.
But that's not what you first told the police back on July 30th of 2020.
No, I gave them Tommy's ID.
Exactly. When they asked for your ID, you didn't give them your ID.
No, I did not.
You gave them an ID that actually belonged to your brother.
I did.
So when the police asked you for ID, you lied to them.
I guess you could say that, yes. I gave them my brother's ID.
Now, you said on direct examination the reason you claimed why you lied to them. And you said that's because on that date you were on probation.
Yes, for stealing some beers.
Exactly. You were arrested back in February of 2020 for trying to steal some beer.
Yes,
And you were sentenced to 2 years probation for that.
yes.
But you claim that you violated that probation, right?
I stopped going to the, seeing the probation officer.
Exactly. You claim that you stopped seeing your probation officer, so that's why you were in violation of your probation.
Yes,
So you knew that there was a warrant out for your arrest.
yes,
So you had a plan in case you ever had to run into the police, right?
yes,
A plan to give the police an ID that didn't want you,
yes, my brother.
a plan to deceive the police.
I guess you could say that, yes.
So you had a plan to lie about your name and who you were in order to avoid going to jail, right?
Yes,
Lying about your name and who you were, it's exactly what you tried to do on July 30th of 2020, right?
that day, yes.
All right, so now that we're clear on the story that you told the police on July 30th of 2020, I want to talk about what your story you're telling the jury here today. Now, you're saying that apartment 123 of the Redwood Apartments, that's not yours?
No, that's my brother Tommy and his wife, Jennifer Willard.
You're saying that the cocaine found inside that apartment, that was yours?
No.
You're saying that both those things were actually your brothers?
Yes.
Why want to talk about some of the things that you were found with that day, because it's true, you were found alone on July 30th, 2020.
I was, they were out.
They never came back while the police were there.
No, they said they were gonna be gone for a couple hours.
Exactly, they said they were going to be gone for a couple hours, but they didn't come back at all while the police were there.
Not while the police were there, no.
Well, since July 30th of 2020, you haven't actually heard from Tommy Williams, have you?
Unfortunately, it seems like he bailed on me.
You haven't heard from Jennifer Williams either?
No, they both failed.
All right, Your Honor, we're going to show the jury Exhibit 8, maybe do so, it's already been entered.
Yes, you may.
Mr. Williams, you'd agree with me that you were found alone in that apartment. A couple of things, I want to circle it now. You were found alone with those 2 bags of cocaine, right?
That was not there, but,
Mr. Williams, my question wasn't where the bags were. You were found in the same apartment as those 2 bags that are served, right?
yes, it was in Tommy's apartment, just not on the first floor where I was.
And you were found alone in the same apartment as that digital scale?
Yes,
Alone in the same apartment as those small turquoise bags?
yes,
As well as those small cut up straws too?
yes,
And you were also found alone in the same apartment as those cell phones that were upstairs, right?
I didn't know about any cell phones.
Well, you've been in trial all throughout the trial today.
I haven't, yes,
You heard Officer Perez say he found 3 cell phones upstairs, right?
that's what he said, yes,
So you were found alone in the same apartment as 3 cell phones.
on a different floor, yes.
Now, you just want this jury to believe that it's a coincidence. You were found alone with all of those tools of a drug dealer?
I wouldn't say it that way, no.
Well, it was just a coincidence that you were alone and your brother and sister-in-law were gone, right?
They were out visiting their children.
So again, it's just a coincidence that you were found alone with all those things.
Sure, I guess you can call it that.
Your Honor, may we approach at this time?
You may.
Your Honor, I'm approaching at this point regarding a motion of limine that was raised by my co-counsel, Ms. Vauklchik, regarding the defendant's silence at a specific moment in time. The circumstances have now changed. We do understand you excluded it, but the circumstances have now changed because the defendant has decided to waive his Fifth Amendment right and take the stand here today. And the Supreme Court is pretty clear on this issue. In the case of Fletcher v. Ware, they've held that we can use that silence to impeach his credibility once he waives that right, because it's rather post or even pre-arrest silence we can go into. And again, we want to go into the exact moment where Officer Perez is walking downstairs with the 2 bags of cocaine.
Response?
Your Honor, at this point, it's the defendant's Fifth Amendment right is still being abused. Really, if what I suspect is opposing counsel is attempting to say that because the defendant didn't immediately claim that the drugs weren't his, then his decision to stay silent is being used against him in violation of his Fifth Amendment right. I don't know the court that Fletcher v. Ware comes from, but it is not binding precedent. And here in the state of Lone Star, we conform fully to the Constitution of the United States.
May I respond to that, Your Honor?
I think I've heard enough. We're going to continue to exclude that statement.
Yes, Your Honor. Now, Mr. Williams, I want to talk about some things you said on direct examination. Now, you said that you let at some point the police inside that apartment, right?
Yes.
But you said that the reason that you did it because Officer Perez made some deal with you.
He did,
Now, you've been in court all throughout the trial today.
I was, yes.
He never mentioned any deal when he got to that stand, did he?
I don't think you asked him about it.
That's not my question, Mr. Williams, sorry. He never talked about some deal when he got on that stand, right?
No, he didn't volunteer that information.
So you want this jury to believe that he just let that out, right?
Yes, he didn't talk about it today.
You want this jury to believe that it's you that actually, or that your story is the one that's right because he actually made you some offer?
Well, he used the warrants that were out for my brother to try and get me to let him in.
Mr. Williams, now Detective Giddings, that you were here when Detective Giddings took the stand, right?
Yes, I was.
And you heard when he told the members of the jury that you confessed that the cocaine found in that apartment was yours.
That's what he said.
So let's pull up Exhibit 8 then. Mr. Williams, that's your cocaine, isn't it?
No, it is not.
So what you're telling the members of the jury is that Detective Giddings took that stand and he lied.
Objection. Speculation.
Overruled.
Mr. Williams, I'll ask my question again. What you want the members of the jury to believe is that Detective Giddings got up on that stand and lied to them.
It wasn't true.
You want the members of the jury to believe they exclude, or that it's Detective Biddings is the one that was telling stories on that stand here today?
I mean, he didn't have a recording of it, so.
All right, Mr. Rhodes. You pass the witness.
Redirect, Your Honor.
Yes, please.
Mr. Williams, you just asked if you were alone, apartment 123.
I was,
Did you ever go upstairs on that day?
no, I did not.
Could you know if anyone was upstairs?
No,
You were also asked about an alleged conversation that occurred with Detective James. Did you ever, on July 30th, say a single word to Detective James?
no, I did not.
No further questions, Your Honor. I just would speak to you.
Yes, you may be excused, sir.
Thank you.
Does the defense have any further witnesses?
No, Your Honor, at this point, the defense rests. We do have a motion to make outside the presence of the jury.
Okay, go ahead.
We'd like to re-urge our Rule 29 motion for the same grounds.
That will be denied.
Yes, Your Honor.
Your Honor, before, at this point, the state closes. Your Honor, before we proceed with closing argument, we just ask for a brief recess.
How much time do you need?
We need 3 minutes. Will that work?
Yes. Type 3, please.
That's right. And during that time, can I set it before?
Yes, you may.
Thank you.
While that is being covered, could I ask on the numerals of the two teams? Because I didn't hear that clearly. My phone is now erased. It didn't revert. One is 346, right?
That's
This
us.
one.
Yes,
349.
thank you. That's all I need.
Ms. Vinky, how much time have you allotted for closing?
Your Honor, I believe that there's 20 minutes remaining. We will reserve time for the bottle before we begin, unless you would like to.
I bumped something further and further on my end. I have a commitment, and I was wondering if there's any flexibility to make closing arguments a tiny bit shorter than 20 minutes.
Oh, yes, Your Honor, it will be. I can instruct her. We usually run around to 10 minutes. Would that be short enough? Or would you prefer shorter?
If we could do 7, that would really help me out. Then I can at least start the call I'm supposed to have been on as I'm leaving.
Yes, Your Honor, I will tell them 7 minutes and then maybe 1 minute for a bottle, 1 or 2 minutes.
Yes.
Yes, Your Honor.
Is that acceptable to you?
I can make it work, Your Honor.
Thank you. I really appreciate it.
That's what we'll proceed.
Your Honor, may I reserve a minute and a half for a vote?
You may.
Regardless of your phone.
Oh.
Not she did.
I go.
Mr. Raley's trying to kill me. Well, he can come up here if I have to leave. I'm just kidding. I was gonna say he can come up here if I have to leave suddenly. Aha, here he is. You may proceed.
Mr. Honor. May I report? Defendant is a drug dealer. He buys cocaine from another drug dealer, takes it from that large clear sandwich sized bag, places it into small turquoise sized bags, places it on top of the digital scale to weigh it for precise amounts. It's not a drug dealer. The defendant is a drug dealer. He's a drug dealer who lives in apartment 123 of the Redwood Apartments. You see, that's why on July 30th of 2020, he was found alone. But that's not what he said when he took the stand here today. But that's also not what he said to the police on July 30th of 2020. You see, time and time again, the defendant's lied. He's lied to the police, and now members of the jury today, he's lied to you. Remember that you can't trust somebody who doesn't tell the truth. And once you catch somebody in a lie, you have to question everything. Next slide. In a moment, I just want to give you a set of instructions. I just want to give you a verdict form. So I want to look at that now. And I'm going to talk about some of the things that she's going to tell you. The first thing is that we as the state, we have a burden in today's case. We have to prove our case beyond a reasonable doubt. And we gladly accept this burden. It doesn't mean beyond all doubt. It doesn't mean beyond a shadow of doubt, just beyond a reasonable doubt. And we have to prove to you two things in today's case. First, that the defendant intentionally or knowingly possessed that cocaine. And second, that he had an intent to deliver it. We don't have to prove that he was selling, that he actually sold that cocaine, but that he intended to. And we've absolutely met our burden by proving those things today. And that's true because we've proven you two things. First, that the cocaine found inside apartment 123 of the defendants. And second was that he absolutely intended to sell it to other people. So let's break that down at one by one. First, cocaine found in apartment 123 was the defendant's, and we know that because he confessed to it. You heard Detective Ash Giddings take that stand here today and tell you that while he was transporting the defendant to the jail, he said that cocaine was mine for personal use. He took a stand here today and told you no, he's lying. So think about it. Who's more likely to lie in this case? The defendant, who we've heard has lied time and time again. He's more than familiar lying. Or a detective with the narcotics division, a detective that has over 20 years of experience. What motivation does Detective Giddings have for him? That's what I want the defense to come up here and answer. He doesn't have it. He's not making anything up. The defendant said that because that was his cocaine. If that's not enough, well, don't you remember when Jean Risk was there? Created a timeline to look at what exactly she told us. You see, she told us the person living in that apartment paid rent every single month until the day the defendant was arrested. After that, the person living in that apartment didn't pay rent. They were nowhere to be seen. And that's because the person living in apartment 123, that was the defendant. I anticipate the defense to come up here and tell you, no, the lease says Tommy and Jennifer Williams. Gene Rispoli knows that the person living in that was Tommy Williams because the person living there told him his name was Tommy Williams, gave him an ID that said his name was Tommy Williams, and signed a legal document. Tommy Williams. We know that the defendant is more than comfortable lying to police about those things. So it makes the list any different. We know that the cocaine found inside the apartment that day was absolutely the defendant's. That's true. It was found in his apartment. Let's go to that setting. He absolutely intended to sell those drugs to other people. Visual scale for things. Small turquoise baggies for placing that cocaine. Same one that we see cocaine here in. Small cut up straws. Doesn't take a narcotics detective to understand what was going on in that apartment, inside the defendant's apartment. He absolutely intended to sell those drugs. In fact, he was found in his apartment with all the tools of a drug dealer. You heard Officer Perez say she found 3 cell phones in that apartment. Who carries 3 cell phones? Drug dealers. Who pays in cash to the leasing manager every single month? Drug dealers. I anticipate they're going to get up there in a moment and tell you, no, that's just a coincidence. You see, that's where the whole piece can be summed up. It's all just a coincidence. Just a coincidence that he was found alone in that apartment. Alone with all tools of a drug dealer. And it's just a coincidence that the person he said lives there, Tommy Williams, he hasn't been seen or heard from since. He didn't come back in those few hours that he told allegedly the defendant he was home. Because that conversation never existed. You see, opposing counsel has said time and time again, today's a credibility battle. That's what they're gonna do when they come up here. They're gonna tell you, Officer Perez and Detective Giddings, they both lied. Well, who's more likely to lie? Who has something to lose in this case? You see, the defendant, he has a plan to avoid going to jail at all times. I heard today that they warrant out for his arrest, so he made sure to have a plan. Well, today he had another one. I don't believe. Don't let him get away with that. I anticipate in a moment this defense is going to come up here. They're going to tell you, well, it was a bad investigation. We haven't tried to hide that fact from you at all. Ms. Maybe came up here, told you it wasn't perfect. Detective Giddings, Officer Perez said that they could have done more, and now I'm telling you that investigation was flawed. But it's not enough to point to a flawed investigation. You see, instead of focusing on the things that they could have done, focus on what they did find. Focus on what the state actually found, and whether that's sufficient to come to a verdict of guilty. It is. All of the facts in today's case, don't let the defense come up here and distract you about that. That's why when you get that verdict form, members of the jury, which I'm going to put up on the screen.
Mr. Ruiz, if you could wrap it up.
Yes, Your Honor. We're going to ask that you find the defendant guilty in this case. That's okay, we don't need to see it. You'll have it in a moment. Because telling the truth, it matters. The defendant clearly hasn't learned that.
May I proceed?
Closing argument. May it please the court. Members of the jury, flawed investigation is exactly what leads to reasonable doubt. We cannot allow in the state of Lone Star for police to pick and choose evidence at a scene. Because when that happens, whether it's intentional or whether it's accidental, the police procedure is violated, as you heard Officer Perez testify. And this man can go to jail. That's how our system is set up. That the state has to prove beyond a reasonable doubt every single element of the crime they charged Mr. Williams with, which is possession of a controlled substance with the intent to deliver. Not possession alone, not lying to the police, not providing a false document, none of those things. No, they have to prove each element beyond a reasonable doubt for the crime they actually charged. I'm going to linger there for a moment on the words beyond a reasonable doubt. Because in our justice system, it is incredibly important. In our criminal justice system, it is even more so. Because see, in a civil case, if you have a car accident and you sue someone for $1 million, your burden in court to prove it is by preponderance of the evidence. More likely than not. Now, if the state is going to come into your home and take your children away, they have to prove it by clear and convincing evidence. But to take away someone's liberty in a criminal court, you have to prove it beyond a reasonable doubt. And this case is full of reasonable doubt. So I want to go through the witnesses that we saw today and highlight exactly why that's true. Officer Perez showed up to apartment 123 and immediately lied to the defendant. He admitted so. He made up a detail to get inside the apartment with no explanation as to exactly why he chose apartment 123. But when he went in to search the apartment for drugs and endangered children, he overlooked all of this critical evidence that the state says Timmy Williams should have known about. This. He walked through a tiny downstairs apartment as an officer trained to investigate, and he missed it. But the state wants you to believe that there's no way that Mr. Williams could have missed it. And this is all of the evidence that they brought, all of the evidence in this photograph, that there was intent to deliver. Now, they talked about some cell phones upstairs, but that evidence wasn't collected. In fact, neither was any of this. None of that evidence was fingerprinted, collected, cataloged. In fact, all of the evidence, other than 2 bags of cocaine, were left exactly where they were. Now, Detective Giddings will tell you that fingerprints weren't that important to this case. They really wouldn't have helped. But fingerprints were exactly how they identified the defendant at the police station on July 3rd. Detective Giddings, at that point, as a 20-year officer and a 7-year detective, should have called Officer Perez and immediately demanded that that evidence be cataloged. But Officer Perez didn't even take the simple task of, while upstairs investigating the pills scattered around the ground, or the pill bottle sitting on the nightstand. Whose name was on that bottle? That's not an answered question. But more than anything, the state has said again and again that Mr. Williams was alone in the apartment. Mr. Williams said he never went upstairs. But we know went upstairs was Officer Perez, and Officer Perez didn't think it was important to look in the closet. And so the jury, that's another unanswered question. The reasonable doubt is beginning to stack up. Now, Detective Giddings claims today that Mr. Williams confessed in the backseat of his squad car on the way to the station. That's convenient, because Detective Giddings didn't report that confession. He never wrote it in any of his police reports regarding this case. No, he just decided to tell you when testifying. That's not how detective work is done. That is not how admissible confessions that you should take into account are provided in court. This isn't credibility matter. Judge the officer on his own credibility. He failed to collect any evidence. He failed to write any of the important things down in a report. He admitted it. Officer Perez failed to do a search, admitted again and again and again that police procedure was violated. We cannot, on the basis of such shoddy police work, lock a man in jail. Justice isn't convenient. It requires more. We heard the state also talk about Janan, who we as the defense had to bring because the state did no investigation as to whose actual apartment it was. But still, they want to tell you that because 3 items matched his twin brother, that should somehow erase all reasonable doubt from your mind as to whose apartment it was. It's ridiculous. Said plainly, Jean Rispoli told you that in her leasing office across the desk, she saw Tommy and Jennifer Williams. That they were there with her, that she provided references, that he provided a social security number. They would have to believe that now suddenly that Tommy and Jennifer were a made-up part of a plan back in December of 2019, before he was ever convicted of that, before he had any reason to engage in this plan of carrying his brother's ID around. The timeline just doesn't make sense. And of course they never saw Tommy Williams again, because he returned in just a couple hours. Police still would have been there. He was gone. Now, while the state has done a lot of work to try to prove that drugs were being sold and drugs were possessed in the apartment on that day, they have completely failed to prove that it was Timmy Williams who had the drugs, or that he had any intention to sell any drugs. It is for all of these reasons. Now, when you go back into the jury deliberation, you're presented with a verdict. That you find the defendant not guilty.
Oh,
Please proceed.
hey, Mr. Court. This isn't a credibility battle. You should assess the officers by their own words. That's what opposing counsel just came up here and said. See, members of the jury, he doesn't want you to believe that you have to assess the credibility of the defendant. Because he knows that he's not going to win that one. He told you, Mr. Williams said he wasn't upstairs. Sure, he said that. He also said that that wasn't his apartment. He also said that that wasn't his cocaine when he took the stand here today. We know that's not true. We know that he's lied time and time. So yes, today is a credibility battle. You're gonna believe two officers of the law or a man who is going to go to jail? Well, I'm guilty. Don't let him get away with lying to every single one. Teach him that that's not okay. Teach him that we're not here. We're not okay with lying to other members. I'm guilty.
Thank you. The jury will now deliberate.